Rome Statute of the International Criminal Court, International Cooperation and Judicial Assistance. Part 9. International Cooperation and Judicial Assistance. Article 86. General obligation to cooperate. States parties shall, in accordance with the provisions of this statute, cooperate fully with the court in its investigation and prosecution of crimes within the jurisdiction of the court. Article 87. Requests for cooperation, general provisions. 1a. The court shall have the authority to make requests to states parties for cooperation. The request shall be transmitted through the diplomatic channel or any other appropriate channel as may be designated by each state party upon ratification, acceptance, approval or accession. Subsequent changes to the designation shall be made by each state party in accordance with the rules of procedure and evidence. b. When appropriate, without prejudice to the provisions of subparagraph a. Requests may also be transmitted through the International Criminal Police Organization or any appropriate regional organization. 2. Requests for cooperation and any documents supporting the request shall either be in or be accompanied by a translation into an official language of the requested state or one of the working languages of the court, in accordance with the choice made by that state upon ratification, acceptance, approval or accession. Subsequent changes to this choice shall be made in accordance with the rules of procedure and evidence. 3. The requested state shall keep confidential a request for cooperation and any documents supporting the request, except to the extent that the disclosure is necessary for execution of the request. 4. In relation to any request for assistance presented under this part, the court may take such measures, including measures related to the protection of information, as may be necessary to ensure the safety or physical or psychological well-being of any victims, potential witnesses, and their families. The court may request that any information that is made available under this part shall be provided and handled in a manner that protects the safety and physical or psychological well-being of any victims, potential witnesses, and their families. 5a. The court may invite any state not party to this statute to provide assistance under this part on the basis of an ad hoc arrangement, an agreement with such state or any other appropriate basis. b. Where a state not party to this statute, which has entered into an ad hoc arrangement or an agreement with the court, fails to cooperate with requests pursuant to any such arrangement or agreement, the court may so inform the Assembly of States Parties or, where the Security Council referred the matter to the court, the Security Council. 6. The court may ask any intergovernmental organization to provide information or documents. The court may also ask for other forms of cooperation and assistance which may be agreed upon with such an organization and which are in accordance with its competence or mandate. 7. Where a state party fails to comply with a request to cooperate by the court contrary to the provisions of this statute, thereby preventing the court from exercising its functions and powers under the statute, the court may make a finding to that effect and refer the matter to the Assembly of States Parties or, where the Security Council referred the matter to the court, to the Security Council. Article 88. Availability of procedures under national law. States parties shall ensure that there are procedures available under their national law for all of the forms of cooperation which are specified under this part. Article 89. Surrender of persons to the court. 1. The court may transmit a request for the arrest and surrender of a person, together with the material supporting the request outlined in Article 91. To any state on the territory of which that person may be found and shall request the cooperation of that state in the arrest and surrender of such a person. States parties shall, in accordance with the provisions of this part and the procedure under their national law, comply with requests for arrest and surrender. 2. where the person sought for surrender brings a challenge before a national court on the basis of the principle of ne bis in idem as provided in Article 20, the requested state shall immediately consult with the court to determine if there has been a relevant ruling on admissibility. If the case is admissible, the requested state shall proceed with the execution of the request. If an admissibility ruling is pending, the requested state may postpone the execution of the request for surrender of the person until the court makes a determination on admissibility. 3a. A state party shall authorize, in accordance with its national procedural law, transportation through its territory of a person being surrendered to the court by another state, except where transit through that state would impede or delay the surrender. b. A request by the court for transit shall be transmitted in accordance with Article 87. The request for transit shall contain I. A description of the person being transported. 2. A brief statement of the facts of the case and their legal characterization, and 3. The warrant for arrest and surrender. c. A person being transported shall be detained in custody during the period of transit. d. No authorization is required if the person is transported by air and no landing is scheduled on the territory of the transit state. e. If an unscheduled landing occurs on the territory of the transit state, that state may require a request for transit from the court as provided for in subparagraph b. The transit state shall detain the person being transported until the request for transit is received and the transit is effected. Provided that detention for purposes of this subparagraph may not be extended beyond 96 hours from the unscheduled landing unless the request is received within that time. 4. If the person sought is being proceeded against or is serving a sentence in the requested state for a crime different from that for which surrender to the court is sought, the requested state, after making its decision to grant the request, shall consult with the court. Article 90. Competing requests. 1. A state party which receives a request from the court for the surrender of a person under Article 89 shall, if it also receives a request from any other state for the extradition of the same person for the same conduct which forms the basis of the crime for which the court seeks the person's surrender, notify the court and the requesting state of that fact. 2. Where the requesting state is a state party, the requested state shall give priority to the request from the court if a. The court has, pursuant to Article 18 or 19, made a determination that the case in respect of which surrender is sought is admissible and that determination takes into account the investigation or prosecution conducted by the requesting state in respect of its request for extradition, or b. The court makes the determination described in subparagraph a, pursuant to the requested state's notification under paragraph 1. 3. Where a determination under paragraph 2a has not been made, the requested state may, at its discretion, pending the determination of the court under paragraph 2b, proceed to deal with the request for extradition from the requesting state but shall not extradite the person until the court has determined that the case is inadmissible. The court's determination shall be made on an expedited basis. 4. If the requesting state is a state not party to this statute, the requested state, if it is not under an international obligation to extradite the person to the requesting state, shall give priority to the request for surrender from the court, if the court has determined that the case is admissible. 5. Where a case under paragraph 4 has not been determined to be admissible by the court, the requested state may, at its discretion, proceed to deal with the request for extradition from the requesting state. 6. In cases where paragraph 4 applies except that the requested state is under an existing international obligation to extradite the person to the requesting state not party to this statute, the requested state shall determine whether to surrender the person to the court or extradite the person to the requesting state. In making its decision, the requested state shall consider all the relevant factors, including but not limited to a. the respective dates of the requests. B. The interests of the requesting state including, where relevant, whether the crime was committed in its territory and the nationality of the victims and of the person sought, and C. The possibility of subsequent surrender between the court and the requesting state. 7. Where a state party which receives a request from the court for the surrender of a person also receives a request from any state for the extradition of the same person for conduct other than that which constitutes the crime for which the court seeks the person's surrender. A. The requested state shall, if it is not under an existing international obligation to extradite the person to the requesting state, give priority to the request from the court. B. The requested state shall, if it is under an existing international obligation to extradite the person to the requesting state, determine whether to surrender the person to the court or to extradite the person to the requesting state. In making its decision, the requested state shall consider all the relevant factors, including but not limited to those set out in paragraph 6, but shall give special consideration to the relative nature and gravity of the conduct in question. 8. Where pursuant to a notification under this article, the court has determined a case to be inadmissible, and subsequently extradition to the requesting state is refused, the requested state shall notify the court of this decision. Article 91. Contents of request for arrest and surrender. 1. A request for arrest and surrender shall be made in writing. In urgent cases, a request may be made by any medium capable of delivering a written record, provided that the request shall be confirmed through the channel provided for in Article 87, paragraph 1a. 2. In the case of a request for the arrest and surrender of a person for whom a warrant of arrest has been issued by the pretrial chamber under Article 58, the request shall contain or be supported by a. Information describing the person sought, sufficient to identify the person, and information as to that person's probable location. B. A copy of the warrant of arrest, and c. Such documents, statements or information as may be necessary to meet the requirements for the surrender process in the requested state, except that those requirements should not be more burdensome than those applicable to requests for extradition pursuant to treaties or arrangements between the requested state and other states and should, if possible, be less burdensome, taking into account the distinct nature of the court. 3. In the case of a request for the arrest and surrender of a person already convicted, the request shall contain or be supported by a. A copy of any warrant of arrest for that person. B. A copy of the judgment of conviction. C. Information to demonstrate that the person sought is the one referred to in the judgment of conviction, and D. If the person sought has been sentenced, a copy of the sentence imposed and, in the case of a sentence for imprisonment, a statement of any time already served and the time remaining to be served. 4. Upon the request of the court, a state party shall consult with the court, either generally or with respect to a specific matter, regarding any requirements under its national law that may apply under paragraph 2c. During the consultations, the state party shall advise the court of the specific requirements of its national law. Article 92. Provisional arrest. 1. In urgent cases, the court may request the provisional arrest of the person sought, pending presentation of the request for surrender and the documents supporting the request as specified in Article 91. 2. The request for provisional arrest shall be made by any medium capable of delivering a written record and shall contain a. Information describing the person sought, sufficient to identify the person, and information as to that person's probable location. B. A concise statement of the crimes for which the person's arrest is sought and of the facts which are alleged to constitute those crimes, including, where possible, the date and location of the crime. C. A statement of the existence of a warrant of arrest or a judgment of conviction against the person sought, and D. A statement that a request for surrender of the person sought will follow. 3. A person who is provisionally arrested may be released from custody if the requested state has not received the request for surrender and the documents supporting the request as specified in Article 91 within the time limits specified in the Rules of Procedure and Evidence. However, the person may consent to surrender before the expiration of this period if permitted by the law of the requested state. In such a case, the requested state shall proceed to surrender the person to the court as soon as possible. 4. The fact that the person sought has been released from custody pursuant to paragraph 3 shall not prejudice the subsequent arrest and surrender of that person if the request for surrender and the documents supporting the request are delivered at a later date. Article 93. Other forms of cooperation. 1. States parties shall, in accordance with the provisions of this part and under procedures of national law, comply with requests by the court to provide the following assistance in relation to investigations or prosecutions. A. The identification and whereabouts of persons or the location of items. B. The taking of evidence, including testimony under oath, and the production of evidence, including expert opinions and reports necessary to the court. C. The questioning of any person being investigated or prosecuted. D. The service of documents, including judicial documents. E. Facilitating the voluntary appearance of persons as witnesses or experts before the court. F. The temporary transfer of persons as provided in paragraph 7. G. The examination of places or sites, including the exhumation and examination of grave sites. H. The execution of searches and seizures. I. The provision of records and documents, including official records and documents. J. The protection of victims and witnesses and the preservation of evidence. K. The identification, tracing and freezing or seizure of proceeds, property and assets and instrumentalities of crimes for the purpose of eventual forfeiture, without prejudice to the rights of bona fide third parties, and L. Any other type of assistance which is not prohibited by the law of the requested state, with a view to facilitating the investigation and prosecution of crimes within the jurisdiction of the court. 2. The court shall have the authority to provide an assurance to a witness or an expert appearing before the court that he or she will not be prosecuted, detained or subjected to any restriction of personal freedom by the court in respect of any act or omission that preceded the departure of that person from the requested state. 3. Where execution of a particular measure of assistance detailed in a request presented under paragraph 1 is prohibited in the requested state on the basis of an existing fundamental legal principle of general application. The requested state shall promptly consult with the court to try to resolve the matter. In the consultations, consideration should be given to whether the assistance can be rendered in another manner or subject to conditions. If after consultations the matter cannot be resolved, the court shall modify the request as necessary. 4. In accordance with Article 72, a state party may deny a request for assistance, in whole or in part, only if the request concerns the production of any documents or disclosure of evidence which relates to its national security. 5. Before denying a request for assistance under paragraph 1(l), the requested state shall consider whether the assistance can be provided subject to specified conditions, or whether the assistance can be provided at a later date or in an alternative manner, provided that if the court or the prosecutor accepts the assistance subject to conditions, the court or the prosecutor shall abide by them. 6. If a request for assistance is denied, the requested state party shall promptly inform the court or the prosecutor of the reasons for such denial. 7a. The court may request the temporary transfer of a person in custody for purposes of identification or for obtaining testimony or other assistance. The person may be transferred if the following conditions are fulfilled. I. The person freely gives his or her informed consent to the transfer, and 2. The requested state agrees to the transfer, subject to such conditions as that state and the court may agree. B. The person being transferred shall remain in custody. When the purposes of the transfer have been fulfilled, the court shall return the person without delay to the requested state. 8a. The court shall ensure the confidentiality of documents and information, except as required for the investigation and proceedings described in the request. B. The requested state may, when necessary, transmit documents or information to the prosecutor on a confidential basis. The prosecutor may then use them solely for the purpose of generating new evidence. C. The requested state may, on its own motion or at the request of the prosecutor, subsequently consent to the disclosure of such documents or information. They may then be used as evidence pursuant to the provisions of Parts 5 and 6 and in accordance with the rules of procedure and evidence. 9a. In the event that a state party receives competing requests, other than for surrender or extradition, from the court and from another state pursuant to an international obligation, the state party shall endeavor, in consultation with the court and the other state, to meet both requests, if necessary by postponing or attaching conditions to one or the other request. 2. Failing that, competing requests shall be resolved in accordance with the principles established in Article 90. B. Where, however, the request from the court concerns information, property or persons which are subject to the control of a third state or an international organization by virtue of an international agreement. The requested states shall so inform the court and the court shall direct its request to the third state or international organization. 10a. The court may, upon request, cooperate with and provide assistance to a state party conducting an investigation into or trial in respect of conduct which constitutes a crime within the jurisdiction of the court or which constitutes a serious crime under the national law of the requesting state. B. The assistance provided under subparagraph A shall include, inter alia, a. The transmission of statements, documents or other types of evidence obtained in the course of an investigation or a trial, conducted by the court, and b. The questioning of any person detained by order of the court. 2. In the case of assistance under subparagraph B, A. If the documents or other types of evidence have been obtained with the assistance of a state, such transmission shall require the consent of that state. B. If the statements, documents or other types of evidence have been provided by a witness or expert, such transmission shall be subject to the provisions of Article 68. C. The court may, under the conditions set out in this paragraph, grant a request for assistance under this paragraph from a state which is not a party to this statute. Article 94. Postponement of execution of a request in respect of ongoing investigation or prosecution. 1. If the immediate execution of a request would interfere with an ongoing investigation or prosecution of a case different from that to which the request relates, the requested state may postpone the execution of the request for a period of time agreed upon with the court. However, the postponement shall be no longer than is necessary to complete the relevant investigation or prosecution in the requested state. Before making a decision to postpone, the requested state should consider whether the assistance may be immediately provided subject to certain conditions. 2. If a decision to postpone is taken pursuant to paragraph 1, the prosecutor may, however, seek measures to preserve evidence, pursuant to Article 93, paragraph 1, J. Article 95. Postponement of execution of a request in respect of an admissibility challenge. Where there is an admissibility challenge under consideration by the court pursuant to Article 18 or 19, the requested state may postpone the execution of a request under this part pending a determination by the court. Unless the court has specifically ordered that the prosecutor may pursue the collection of such evidence pursuant to Article 18 or 19. Article 96. Contents of request for other forms of assistance under Article 93. 1. A request for other forms of assistance referred to in Article 93 shall be made in writing. In urgent cases, a request may be made by any medium capable of delivering a written record, provided that the request shall be confirmed through the channel provided for in Article 87, Paragraph 1a. 2. The request shall, as applicable, contain or be supported by the following. A concise statement of the purpose of the request and the assistance sought, including the legal basis and the grounds for the request. B. As much detailed information as possible about the location or identification of any person or place that must be found or identified in order for the assistance sought to be provided. C. A concise statement of the essential facts underlying the request. D. The reasons for and details of any procedure or requirement to be followed. E. Such information as may be required under the law of the requested state in order to execute the request, and F. Any other information relevant in order for the assistance sought to be provided. 3. Upon the request of the court, a state party shall consult with the court, either generally or with respect to a specific matter, regarding any requirements under its national law that may apply under paragraph 2e. During the consultations, the state party shall advise the court of the specific requirements of its national law. 4. The provisions of this article shall, where applicable, also apply in respect of a request for assistance made to the court. Article 97. Consultations. Where a state party receives a request under this part in relation to which it identifies problems which may impede or prevent the execution of the request, that state shall consult with the court without delay in order to resolve the matter. Such problems may include, inter alia, a. Insufficient information to execute the request. B. In the case of a request for surrender, the fact that despite best efforts, the person sought cannot be located or that the investigation conducted has determined that the person in the requested state is clearly not the person named in the warrant, or C. The fact that execution of the request in its current form would require the requested state to breach a pre-existing treaty obligation undertaken with respect to another state. Article 98. Cooperation with respect to waiver of immunity and consent to surrender. 1. The court may not proceed with a request for surrender or assistance which would require the requested state to act inconsistently with its obligations under international law with respect to the state or diplomatic immunity of a person or property of a third state, unless the court can first obtain the cooperation of that third state for the waiver of the immunity. 2. The court may not proceed with a request for surrender which would require the requested state to act inconsistently with its obligations under international agreements pursuant to which the consent of a sending state is required to surrender a person of that state to the court, unless the court can first obtain the cooperation of the sending state for the giving of consent for the surrender. Article 99. Execution of requests under Articles 93 and 96. 1. Requests for assistance shall be executed in accordance with the relevant procedure under the law of the requested state and, unless prohibited by such law, in the manner specified in the request, including following any procedure outlined therein or permitting persons specified in the request to be present at and assist in the execution process. 2. In the case of an urgent request, the documents or evidence produced in response shall, at the request of the court, be sent urgently. 3. Replies from the requested state shall be transmitted in their original language and form. 4. Without prejudice to other articles in this part, where it is necessary for the successful execution of a request which can be executed without any compulsory measures, including specifically the interview of or taking evidence from a person on a voluntary basis, including doing so without the presence of the authorities of the requested state party if it is essential for the request to be executed, and the examination without modification of a public site or other public place. The prosecutor may execute such request directly on the territory of a state as follows. A. When the state party requested is a state on the territory of which the crime is alleged to have been committed, and there has been a determination of admissibility pursuant to Article 18 or 19. The prosecutor may directly execute such request following all possible consultations with the requested state party. B. In other cases, the prosecutor may execute such request following consultations with the requested state party and subject to any reasonable conditions or concerns raised by that state party. Where the requested state party identifies problems with the execution of a request pursuant to this subparagraph, it shall, without delay, consult with the court to resolve the matter. 5. Provisions allowing a person heard or examined by the court under Article 72 to invoke restrictions designed to prevent disclosure of confidential information connected with national security shall also apply to the execution of requests for assistance under this article. Article 100 Costs. 1. The ordinary costs for execution of requests in the territory of the requested state shall be borne by that state, except for the following, which shall be borne by the court. A. Costs associated with the travel and security of witnesses and experts or the transfer under Article 93 of persons in custody. B. Costs of translation, interpretation and transcription. C. Travel and subsistence costs of the judges, the prosecutor, the deputy prosecutors, the registrar, the deputy registrar and staff of any organ of the court. D. Costs of any expert opinion or report requested by the court. E. Costs associated with the transport of a person being surrendered to the court by a custodial state, and F. Following consultations, any extraordinary costs that may result from the execution of a request. 2. The provisions of paragraph 1 shall, as appropriate, apply to requests from states parties to the court. In that case, the court shall bear the ordinary costs of execution. Article 101. Rule of Speciality. 1. A person surrendered to the court under this statute shall not be proceeded against, punished or detained for any conduct committed prior to surrender, other than the conduct or course of conduct which forms the basis of the crimes for which that person has been surrendered. 2. The court may request a waiver of the requirements of paragraph 1 from the state which surrendered the person to the court and, if necessary, the court shall provide additional information in accordance with Article 91. States parties shall have the authority to provide a waiver to the court and should endeavor to do so. Article 102, Use of terms. For the purposes of this statute. A. Surrender means the delivering up of a person by a state to the court, pursuant to this statute. B. Extradition means the delivering up of a person by one state to another as provided by treaty, convention, or national legislation.